Hi, it's Roland Jones. Thanks for watching again one of my videos. This slide shows about the ethical issues involved in purchasing bankruptcy claims and litigation. In other words, we're going to be focusing on buying lawsuits that the trustee could bring. In other words, can a third party, can somebody off the street just go to the trustee and say, "Hey, you've got a lawsuit, you got a right to bring a lawsuit against someone. I'm going to buy that from you." um, and uh, and do it myself. So there are a lot of different cases on this and interesting ethical issues. First case we're going to look at is Henry Greenberg's 2001 case, where you have what appears to be a very angry creditor. So in this case, I'll just give you a little bit of background information. Robert Greenberg actually went to prison for apparently defrauding the insurance company Chubb and Son. And Chubb was not too happy about that. They brought a RICO action. They brought everything but the kitchen sink against this guy. And they wanted to take over a fraudulent conveyance action. Trustee brought a fraudulent conveyance against Robert and his wife, seeking to claw back monies that were paid by the debtor back into the bankruptcy estate. And the trustee made a deal with his wife, Leslie. It says, okay, we'll settle for 150. And so, and Chubb submits, we'll settle the case for 150 with Leslie. So Chubb objects, says, no, that's no good. They don't want to let her off so easy. I mean, they offered the trustee 175 for a gigantic insurance company like Chubb. I'm not sure what the big benefit is of pursuing this guy's wife and offering to pay 25,000 more. What's the difference? But like I said at the beginning, this sounds like a very angry creditor. And the trustee's in an unusual position here. The trustee brought a lawsuit. It was settled, and usually the trustee operates under the business judgment rule. And here, all of a sudden, Chubb is objecting and says, "No, you got paid 150. We'll pay you 175 for the action." So trustee was in sort of an interesting spot there. Is it okay to let a creditor go after a defendant in a fraudulent conveyance action, or should the trustee be limited to doing that? But it's sort of a weird feeling because the trustee is assigned to do that. He's got jurisdiction to do that, and why just let a creditor do that? So what's interesting also about this case is that Chubb was basically the only creditor, had 99% of the claim against the estate. So maybe there was another creditor, but a small one. And so the judge was faced with the issue of, do we let a creditor, in this case, basically there's only one creditor, but do we let a creditor take over the trustee's role as the plaintiff in a fraudulent conveyance action? Well, an objection was brought in, of course, by the wife, who could not have been happy about this turn of events, um, and cited some case. She had a lawyer, cited some case law that said, no, these can't be assigned. These belong to the trustee. You can't just assign these rights, avoidance powers to people whoever want to do these things. I mean, you could have. I think it's an ethical issue because you could have creditors that are buying these things to harass people or for other reasons, or maybe to pursue frivolous actions. Um, I mean, if they can be sold easily, anyone can go in and buy it. And do we really want that to happen? Well, in this case, the court looked at the case law, which basically said that, if you sell these things and one creditor gets to buy a fraudulent conveyance action at a discount and then makes a lot of money, that's not fair to it appears not to be fair to other creditors because, other creditors are going to say, hey, why did the trustee sell that for 175 and and this creditor was able to recover 500,000, it doesn't seem fair, or it doesn't appear, uh, doesn't doesn't cast a good um, appearance of propriety on the system. So there's some reluctance to do that. But here the judge said, hey, Chubb is the creditor. There aren't any other creditors that are going to object. There's 99% of all outstanding claims. So, what's the harm? Plus, they're offering to pay 25K more. And where's the money going to go anyway? It's going to go to them. So the whole thing is kind of stupid, in my opinion. And this is sort of a much to do about nothing. But it's an important issue. And here the judge decided, look, there's no appearance problem because they're the only creditor and they're paying more, and the judge said fine. And Chubb was able to buy the claim. The fact pattern is weird here. The issue is important, and I'm not sure the holding could really apply to a lot of other cases because usually there are more creditors, but that's what happened here. And the issue doesn't come up a lot. It did come up here. Okay, we're going to move to another case, which I think is actually much more weighty. It's a Fifth Circuit case. That means it's at the highest level, Court of Appeals. So this is the highest level before the U.S. Supreme Court. Very, very persuasive for a lot of bankruptcy, not persuasive, binding for a lot of bankruptcy courts. Persuasive for a lot of other bankruptcy courts that are not in that circuit. 2010 case, fairly recent. Well, in this case, the trustee is going after James Moore for a fraudulent conveyance. This is James Moore's bankruptcy, and he's running out of money. There are complications, and there's no money to continue. And a creditor, Cradle Co., went to the trustee and said, "Hey, you don't have any money. Let me buy the claim, and I'll give you 10,000 for it. Give that to the creditors, and that's it. And I'll do with the claim. I'll try to collect. If I can't, it's too bad. Whatever." And so they start negotiating, and without telling Cato, the trustee proposes a settlement with Mr. Moore for 37,500. Cato finds out about it and calls the trustee and says, "Hey, I'll give you 50K for it." So that has to be better for creditors than 37,500. It's a no-brainer. I'm giving you more money, so sell me the claim, and then I'll go after more until the cows come home. So that's the situation. So the question is, can a trustee sell? Again, can a trustee sell a cause of action, especially an avoidance action? Just sell it like he's selling other assets? Or is this something that can't be sold? I mean, one of the issues that comes up a lot in these cases is the issue of champerty. A lot of states have laws against buying lawsuits or buying claims with the intent of bringing litigation. And is this ethical to allow someone to buy a lawsuit and perhaps engage in frivolous conduct or buy it for the purposes of harassment? So one of the questions here is whether the trustee can even sell this. Is this property of the estate? Does this belong to the estate, or is it just a right that's specific to the trustee? Of course, according to Cato, I'm offering more money, so we're maximizing value for creditors, and I should be able to do what I want with the claim. It only makes sense. The trustee countered, "Hey, I've got to, that's not the standard. The standard is reasonableness. That's the standard, the business judgment rule. Is it reasonable? Was my settlement reasonable or was it not settlement? It doesn't matter whether someone else comes in. That's not how it's done, essentially." The trustee is saying. Well, there were a couple of claims. I'm going to focus on the fraudulent conveyance claims, and basically the Court of Appeals said that yes, these can be sold. Now the court did make a distinction between Texas-based fraudulent conveyance claims, which can be pursued in bankruptcy court, and bankruptcy-based fraudulent conveyance claims under 548. So the court said, well, didn't address the 548 claims because there weren't any. The only claim that the trustee was asserting was a Texas state law fraudulent conveyance action, and the court said the trustee inherits this from the creditors when the case is started, and anything he inherits from creditors, under 544 is property of the estate, and so this is property of the estate. So he can do what he wants with it. He can sell it. And the court did not address the issue. If the trustee had a 548 case, could he sell that? The court didn't address that, but reading between the lines, my strong impression is that the court would approve that as well. But who knows? Anyway, that was the decision of the court. You can, in Texas, the trustee has a state-based 548 action, you can go ahead and buy it and litigate to your heart's content. Also, the court, as I should say as a sideline, one of the arguments and one of the rationales is that there's got to be a 363 motion, which means there's got to be a motion pursuant to that section of the code and a hearing, and the judge has got to approve the sale. So there's some process here, some oversight to selling it. They're not just selling them on eBay. They've got to go to court, and the judge has got to make sure everything is proper here, and then sell it on eBay. So anyway, I'm not sure really how the court is, what the process, what's the purpose of that process? Is the court going to ask the buyer, do you just want to buy this to harass the guy, or are you buying it because you want to make money? I mean, I don't know. It just seems kind of silly to me. But at any rate, there's process here, supposedly to protect who? Creditors? They're getting a higher number. So what's interesting in this case is the issue of, so let's say the trustee, again, the issue like in the last case, it wasn't raised, or the court didn't address it. So let's say this fraudulent conveyance action is sold for whatever it was, $37,500, and Cadle, excuse me, brings in $100,000. So other creditors are not going to see any of that money. Is that fair? Is that right? Is that ethical? I guess so. I guess the decision is, hey, this is a piece of property, a car, anything else, and if the buyer can resell it or somehow get a higher price for it, God bless them. What's the difference? It's being sold on the market. But this was not an auction, and that's another issue, whether these rights to sue other parties, should be sold at auction, which is a true market value. Here, there was just a proposal, and there was no auction process. Next case we're going to take a look at is a very recent case, 2016, bankruptcy court level, not circuit level or district level. So it's at the trial, essentially the trial level, bankruptcy court level. And it's an interesting case. In this case, essentially it's a breach of contract. It started out as a breach of contract action between essentially two entities in the oil business. Al Salah had contracted with IOTC, an oil trading company, and for whatever reason, the relationship went south, and Al Salah sued IOTC using a litigation funder, Burford Capital, and this is pre-bankruptcy. So pre-bankruptcy, Al Salah enters into an agreement with Burford Capital, and what exactly that agreement is not disclosed. Obviously, it's going to be some interest in the outcome of the case in a judgment. Well, they get a judgment, but it's no good. They try to collect on the judgment. That's no good. So I'm assuming they have an investment in, at least Burford has an investment in some serious money at this point, and they're not about to give up now. They put IOTC, which is a company based in Florida, in involuntary bankruptcy. Now that they're in bankruptcy court, IOTC seeks to dismiss the involuntary petition, and one of the tactics it takes is to compel production of documents. Basically, they want to see the agreement. They want all the records between Al-Salah and Burford, and the purpose of that is pretty clear to everybody. What they're saying is that Al-Salah's, the plaintiff here is not the real plaintiff. The plaintiff creditor is Burford, and Burford has nothing to do with the litigation, the underlying litigation between Al-Salah and IOTC. And so they're going to seek documents to show that this is very, very improper, and Burford, and that the entire involuntary bankruptcy should be dismissed. So the narrow issue is whether communications between a plaintiff and his funding entity, a third-party funding entity, should be allowed. The question is, the funding agency is not a lawyer, so does the attorney-client privilege apply, or it doesn't apply? So they argue that issue, but as we'll flip through, you'll see the real issue is, if you read between the lines in this opinion, the real issue is, was this improper that Al-Salah had a relationship with a funding company, and the funding company does have an interest in the outcome of the matter, and is it appropriate to file an involuntary bankruptcy petition in the circumstances where you have a party, a third party, Burford, not really the plaintiff. It's just funding the litigation, and it's going to get a benefit from the outcome. Is this appropriate? Is this right? Well, the court, in my opinion, reading between the lines, bent over backwards, and found there isn't an attorney-client relationship, but there is an agency relationship, and under the agency exception, that's meant to protect communications between not only a party and the lawyer and that party's lawyer, but also other folks that are involved in helping to prosecute or manage the case. And the court went into some law, for example, a paralegal or another party, a service provider that's involved in the case. In other words, other folks that are not the lawyer but that are involved in the case. Anyway, the court found that this applied, and seemed to me to apply it rather broadly, to include the funding entity. And the court went out of its way, though, in dicta. In other words, in a section of the opinion that's not really a legal holding, the court went out of its way, pretty obviously, to say, hey, there's no other way Al-Salah could have pursued this, either in state court or in bankruptcy court. This debtor owed Al-Salah a great deal of money. Al-Salah acted properly at all times in engaging a funding agent, and without the funding agent, Al-Salah would not be able to assert his rights either in state court or bankruptcy court. And the court spent some time supporting the concept of a funding agent. Also, the court said that even if the debtor were able to obtain documents, the court, of course, didn't make a ruling, but seemed to say that the court would be unlikely to find this to be a proper arrangement, even if the documents showed that Burford had a large interest in the outcome, in the results of any outcome. So, between the lines, the court seems to say that in dicta that certainly is taking a sympathetic view to relationships with funding entities and the entire concept of having a funding agency, a third party, take an interest in a litigation in which it's not really a part of. So I think that's a hint on at least what's going on in Florida with respect to the attitude towards funding agents, at least in front of this particular judge. This I got ahead of myself a little bit, but this slide relates to the rationale of why the other rationales why the funding agreement does not need to be is protected and does not need to be handed over to the debtor. This is another case that deals with buying lawsuits or funding lawsuits, and I think there certainly is a gray line between funding and buying. Anyway, this is a North Carolina case that deals with the issue of champerty, which is another issue that comes up in the context of these cases. This is a 2017 case. I'll show you what a hot issue this is. This was decided a few months ago from the making of this slideshow. Okay, so essentially what happened here is the trustee is suing former managers for fraudulent conveyance. Looks like a very expensive endeavor. There are a lot of defendants. They're widespread. They are well funded with, I don't think that's in my slide, but it's in the opinion. They're well funded with, oh, it is. They're well funded with insurance policies. And so the trustee's thinking, how am I going to, there is apparently is not enough money in the estate to fund this huge litigation. And so she makes a deal with RDSL, a third-party funding agency who's going to advance the costs on a quarterly basis. And the question is this permissible? You have a third party that's stepping in, doesn't have anything to do with this. And of course, you know, this is, to me, this is always a hot issue because from the defendant point of view, here you have someone that's completely unrelated stepping in and financing a lawsuit against you just to get having nothing to do with justice, but just to get paid, just as an investment. So I think it's inherently offensive to defendants, and that sort of relates to what happened in this case and the issue of champerty. Well, the opponents argue a couple of different things, but one of the bases for objecting to obviously backtrack a little bit, the trustee made a motion to approve this agreement with RDSL, and so there were objections filed. One of the objections is that this would constitute champerty. The selling or financing of this lawsuit would constitute champerty. The trustee says, without the agreement, I'm out of luck here, and it would benefit creditors, and it's not champerty because RDSL is no control over the litigation. It's just passive investor. Well, the court looked into what champerty is, and champerty is essentially the term of art is officious meddling by a third party in a litigation by either purchasing the litigation or funding and then having rights to the outcome of litigation. And this is a statute that exists in North Carolina. The court noted that in other jurisdictions, other states, the statute either doesn't exist or it's much more watered down. For example, the court mentioned California and Connecticut. But in the sovereign state of North Carolina, it's alive and well, and these folks do not like people to buy lawsuits or to fund them. And the issue is one of control. Essentially, the court looked at North Carolina cases and came to the conclusion that whether one of the main factors in determining whether a purchase of a lawsuit or financing of a lawsuit is champertus is depends on the degree of control by the purchaser or financer. It cited a case where a financing entity financed personal injury litigation, but then just stood back and had nothing to do, had no control, just cut a check, and that's it. In that case, the financing was not champertus, and that was by the North Carolina Court of Appeals, the highest state court in North Carolina. However, in this case, the court found that this agreement was champertus. Why? Because a couple of different factors, and the court basically, the most important factor found by the court was that RDSL could have cut off funding at any time. So if it didn't like what was going on, i.e., its input was ignored, possibly, it could just cut off funding. And the trustee already admitted without the funding, there wouldn't be any of these lawsuits. So the court basically said, look, RDSL is really in de facto control here, because if it cuts off the funding, this thing is not going to proceed. It's not going to go anywhere. And the way the court put it, RDSL had the power of the purse. And so the court found, hey, you had too much control here by a third party financier, purchaser, whatever it is. And so this is champertus. When a third party has too much control over the litigation, it's offensive to the sensibilities in North Carolina. So takeaway here is, well, the implication certainly is that you're not going to buy any of these lawsuits from a trustee according to this particular ruling, because then you have total control. Maybe you can finance lawsuits if you can show you have no control, but the structure of the agreement would have to reflect certainly this opinion, especially if you're in this particular court. This is a Third Circuit Court of Appeals case, and the court looked at a situation, a fact situation that involved a purchase and sale agreement of a number of assets of the debtor, and the issue is whether the purchase and sale agreement included fraudulent conveyance actions. Cybergenics had been, you might say, the victim of a leverage buyout and saddled with tremendous debt, wasn't able to pay, bankruptcy, and all the assets were sold. And the creditors committee is thinking, hey, we got some great fraudulent conveyance actions here, because it's a leverage buyout, and there's certainly an argument that there was a fraudulent conveyance to the shareholders. And so the question is, let's go ahead and bring these actions. And then the committee's thinking, well, were these sold? Was this part of all the assets of the bankruptcy case? And of course, the creditors committee is saying, no, we want those retained with the debtor, and we're going to argue that those weren't sold. And so this was litigated, and the question came down to, or the way it was framed by the Third Circuit, was, are fraudulent conveyance actions something that can be considered property of the estate that can be sold, or is this just a sort of a right by the trustee, a special power that he has that is limited to the trustee, and it's not property. So that's the question that the Court of Appeals framed and that they tried to answer. The fraudulent conveyance action at play here was apparently based on a state law. It's important because the court's decision is based on a state law-based fraudulent conveyance action, which is different from a 548 bankruptcy code-based fraudulent conveyance action. And I'll go into why in a second. So those are the arguments. Well, the court came to the conclusion, Court of Appeals came to the conclusion that under New Jersey state law, the fraudulent transfer claim belongs to the creditors, not the debtor. So it can't be sold. Again, this holding is limited to a state law-based fraudulent conveyance claim. And the rationale is, hey, this belongs to the creditors, never got somehow magically transferred to the debtor. It's not debtor property. It could be prosecuted by the trustee, but it doesn't belong to the debtor. That was the conclusion by the Court of Appeals. Well, this is another Second Circuit case. This is district court level where uh, the court disapproves, or in the last case, it wasn't really a disapproval of the sale. It was the determination of whether a state-based fraudulent conveyance action was property of the state. Here, there's more of a disapproval of a sale and a rationale. So in this case, debtor goes bankrupt, and there's a fraudulent conveyance action, there's a constructive trust action, and there's a settlement proposal by the trustee, and there's a creditor who's not loving this, wants to continue pursuing this matter against apparently the wife of the debtor. And the trustee does not bring an offer is made. The 90,000 obviously purposely made a little bit higher than the settlement amount, which was 85,000 by Republic, the creditor. And the trustee doesn't bring it to the attention of the court. There's an objection to the settlement, and the court is faced with the issue of whether, or the district court is, the bankruptcy court and the district court are both faced with the issue of whether the settlement should have been approved or over the objection of Republic, who's offering a higher number. So why would the bankruptcy court reject that if it's going to bring more money into the estate? Doesn't that benefit creditors? And those are the arguments. Well, the district court agreed with the bankruptcy court, which approved the settlement, and over the objection of a higher bid for this lawsuit. The rationale is that you don't want to allow one creditor to buy a claim, to buy a lawsuit cause of action belonging to the debtor, and then go out and collect on it. Why? Because of the policy that all creditors should be treated equally and benefit equally. And so the concern here is, hey, one creditor is going to buy this thing and make out like a bandit, and the other creditors are not going to be part of this or enjoy the bounty, be part of this windfall. And this is a Connecticut case, and Connecticut has a strong champerty law, as we've seen before, and I think that was part of it. It's just an opinion and a perspective that is negative to people buying lawsuits and going out and pursuing them. In this situation, the court specifically said, hey, it's not a situation where Republic's the only creditor. If the court basically, read between the lines, that was implying that if Republic had been the only creditor, then it's less of a problem. It seems to imply that, although the issue of champerty didn't have to come up because the district court ruled on this issue, and the rationale is it's not the only creditor. there are other creditors, and we don't want one creditor making out like a bandit. Uh, I personally disagree with the rationale. I don't think it makes a lot of sense because why wouldn't? Who cares if Republic, is going to take a chance and invest money in this lawsuit and do better? Who could? Who cares? Because creditors are getting more money than they're getting now. They're going to get, in this case, not a lot more money. So maybe that was part of the decision also. They're going to get $5,000 more divided among creditors. So it's bupkis. Maybe if Republic had offered twice as much as the settlement, would the court have had a different opinion? It would certainly be a stronger argument that that the creditor body as a whole would be better off taking Republic's offer and letting Republic have the claim. But here, uh, you know, I really don't know if the numbers would have made a difference. It certainly was not alluded to by the court, but that's the court's decision. It's a public policy. It's a bankruptcy policy. It's Champerty is a public policy based decision. This is more of a bankruptcy policy decision. Creditors should be treated equally, and it's just improper for one creditor to be treated differently. This is another case where the purchase of lawsuits was declined by a court, bankruptcy court level, Eastern District, New York, 2003. I found this case to be, the rationale was pretty much similar to the last case, although a little bit different. It's a public policy situation. So there's a trustee, there are actions um, uh, that remained with the debtor. There's an offer by this time a shareholder to purchase um, a trustee's right to pursue avoidance actions. And there's an objection by another party. And so the court has to make a decision as to whether these actions can be sold to this shareholder, Joseph Shelley, or whether this must be declined. Also, it is an important part of the fact pattern is that the trustee would have nothing. This wasn't a financing agreement where the trustee and trustees council is pursuing it. This trustee's out of the picture. This is just a straight purchase, and the benefit to the estate is the purchase price. The rest goes to the purchaser. Anything above that, which obviously makes perfect sense. So those are the arguments. Well, I found the opinion kind of interesting, and the opinion was, well, the trustee already investigated these claims, and they didn't have any merit. So why should we sell them? To me, that doesn't make a lot of sense. We should sell them because it's going to bring money into the estate. Who cares if they have merit? If Shelley's going to pay good money that can be distributed to creditors, that's Shelley's problem. It's really a Champerty policy decision. What's what if how I interpret this decision is we don't want people buying claims that have no merit to go out and harass people. That's not. It just doesn't look good, and it's not good policy, and we're not going to allow it. I think it's more Champerty based than anything else. In addition, there's the argument we saw in the Connecticut case. Hey, we're not going to let one creditor, uh, you know, somehow obtain a windfall and pursue his own agenda, maybe to harass um, or to file frivolous actions. So, this is not going to benefit the trustee's estate because the purchaser is not representing all creditors. And it's sort of, to me, there's sort of a smell test there. It stinks. We're not going to sell one claim so that the buyer can go out and harass somebody. Um, and also, there's the basic bankruptcy policy that is being articulated here. We saw in the last case. These actions are supposed to benefit all creditors. It doesn't look good if one creditor is benefited. Of course, the counter argument to that is that's his problem, whether he's going to be benefited or not. The judge just opined that the cases are valueless anyway, and why shouldn't the creditors be able to accept money for these claims? So that's the counter argument. Also, the judge added, "Hey, there's not going to be any end in sight to this litigation here, and this thing just needs to be resolved." So, what's the rationale there? Sounds like a Champerty public policy decision. We're not going to allow people to buy claims just to make trouble. Putting an end to the litigation and distributing whatever's left that's our job here, and it's not worth a little extra cash to to let this guy buy these rights and make a lot of trouble. So, policy decision. This is another case involving doctrine of Champerty, 2002 bankruptcy court level, Southern District, New York. Well, this is a situation with two people. How should I say it? There's no love lost between these two. Um, this is an investor in a condominium. The debtor apparently developed the condominium. Silverman was the investor in the condominium. Very unhappy with Lynn, the debtor, and the court referred to extensive litigation that was going on, but didn't detail it. Anyway, Silverman eventually testified as a victim in Lynn's bankruptcy fraud case, and Lynn was convicted of bankruptcy fraud for reasons unrelated to this case. Anyway, Silverman purchased an unsecured claim in Lynn's case for $50 in the face amount of over $177,000 prior to apparently it coming out that there was an allegation of bankruptcy fraud. And Lynn objected to the claim for a number of reasons. One of them was the doctrine of Champerty, and the court had to decide whether Silverman's purchase of a bankruptcy claim should be somehow invalidated. Well, the court looked at the current law on Champerty, which is this statute. These are the arguments. Silverman's argument is not Champerty. I didn't buy the claim to harass anybody. I bought the claim to make money. It's not for harassment. And as we'll see in a second, that's an important distinction. Silverman is, I'm sorry, Lynn's argument is, hey, there's just continuing pattern of harassment by Silverman that's never going to end, and this claim should be disallowed or invalidated. Well, the court looked at the law on Champerty and basically found that according to the Second Circuit, it's a very, very circumscribed doctrine in New York. The doctrine basically says that if buying a lawsuit or buying a claim, if the only purpose was to harass, then it's Champerty. But if another purpose was to make a profit, or the primary purpose was simply to make a profit, and that involved filing a lawsuit, that's not Champertus. The only way it can be Champertus is if the only purpose is to harass, and that's the court found that certainly wasn't the case here. He simply brought a claim in a bankruptcy case. He didn't do anything about it. He didn't pursue it. There was nothing to pursue. It's the trustee's job to pursue uh, bankruptcy litigation on behalf of an estate of creditors, and Silverman's going to get whatever he's going to get. Anyway, the court denied the motion, but the important takeaway here in the context of buying claims and lawsuits in bankruptcy is that champerty is a very limited doctrine in New York, and it's a state by state analysis. In New York, if the purpose is to make a profit, and litigation results or is part of that, um, or is required to make a profit, then it's not champertus. The Ducker-Spradling case is a very significant case in the context of buying lawsuits. This is a circuit level case, a Ninth Circuit, and go into the facts and the holding. Okay, so similar fact pattern. Trustee um, has some potential avoidance actions, the largest being against the former law firm of the debtor, Ducker-Spradling. And but the trustee doesn't have enough money to go after these folks and finance this litigation. And so one of the creditors, Baum, comes along and says, "Look, I'll buy this claim and this and some other claims for $50,000, and if you sell me the right to pursue these lawsuits, sell me these claims, I will give back 50% of any recovery to the bankruptcy estate." So there was an objection by no surprise, the law firm who couldn't have been too happy about this turn of events. First, the trustee was about to abandon the claim against them, and it's a substantial claim, and then all of a sudden, Baum shows up and says, "Hey, I'd love to sue these guys. I'll buy the claim." So you can imagine that this potential defendant was why they were fighting this. It was not a big surprise. So, can the trustee assign its rights? Can a creditor buy these and pursue claims on behalf of creditors, given that it is giving 50%, but only 50% of the recovery to creditors? Well, the debtor made some arguments, and I believe that the law firm also joined in and made some arguments. The court ruled, yes, this can be sold. First of all, there's precedent for assigning rights to a representative, assigning avoidance litigation rights to a representative, if the representative is acting on behalf of all creditors. And here, Baum is, to the extent that he's going to return 50% of the net proceeds. That's good enough. So it's not 100%, 50% is good enough. He's acting on behalf of all creditors. He can keep 50%. And so it's an interesting fact pattern. What if Baum was keeping 100%? Probably the judge would have prohibited the sale. What if Baum, returned 25%? Who knows? But in this situation, the court found that Baum was acting on behalf of all creditors to a sufficient extent to permit the transaction to proceed. And this is a Court of Appeals level. Again, reading between the lines, there's an impropriety test here. There's a smell test. I just think that the judges are going to be really uncomfortable if creditors are not getting back anything, and you have one creditor who's getting a windfall. It just goes against the basic bankruptcy principle of equality of treatment to creditors. Here, 50% was enough. Since they're not going to get anything, if Baum didn't finance and buy these claims and get nothing, 50% was enough to take that smell away and to provide a veneer of propriety, since now Baum is essentially acting on the creditor's behalf, at least to some extent. This is another Ninth Circuit case, Court of Appeals, 2005. I'm not going to pretend I know how to pronounce these names. At any rate, the fact pattern is a debtor is sued before filing for bankruptcy by the appellants, and they're not getting anywhere, and goes bankrupt, and the only way they're going to recover, they claim to be owed $10 million. So the only way they're going to recover is if there's an avoidance action initiated against the debtor or apparently his brother-in-law, that these plaintiffs believe will result in recovery. And so, a similar fact pattern, trustee doesn't have the money to do that, and so the plaintiffs Simon Tab and Lahijini offered to purchase these claims and provide 50% to unsecured creditors, 50% of net recovery to all creditors. It's kind of humorous here is that the debtor's the potential defendant here, the debtor's brother-in-law, and a co-defendant formed the company to also buy these avoidance actions with no percentage recovery. And it's pretty clear he's not going to sue himself. So basically just to wipe out any potential claim against himself, you've named the company claims prosecutor, and the and the court said that wasn't a very good name. It should have been called Claims Eliminator LLC. Anyway, the court now had two offers for these avoidance actions, and there was an auction during which the trustee, for some unknown reason, would not permit any offers to provide a percentage recovery to the creditors. He stated he only wanted a sum certain, and the bankruptcy court did not interfere with that stricture, and claims prosecutor or eliminator, whatever you want to call them, was the highest bid. So the court granted the sale under 363 as property of the estate, and Camille and Nasir appealed, and the higher court was faced with a decision as to whether the sale should have been approved or not. Arguments as described. Well, there was no issue that the avoidance actions could be sold, no doubt about that. But the court looked at what happened here and said, look, the court should have taken a more active analysis of the value of these avoidance actions, and should have been overruled the trustees, or made an independent analysis which would not involve the trustees' stricture that percentage recovery should not be permitted. And the appeals court said that basically didn't make any sense to the appeals court why the trustee wouldn't allow a percentage recovery. And basically the court said, hey, the whole thing was thrown off because of that, and it's possible that the plaintiff's offer was of more value because they did want to offer, in addition to the sum certain, they wanted to offer a percentage of the recovery to unsecured creditors. And the court, in a footnote, noted that a present value analysis should have been done here to determine the value of that percentage, and none of that was done. And so the court reversed the sale, not because these things can't be sold, and not because one of the purchasers was the potential defendant, but because it wasn't the sale process was not proper, and the bankruptcy court was directed on remand to provide a fair and equitable settlement standard analysis of the sale. Conclusion: yes, it can be sold for a sum certain. There's no doubt about that. The court specifically said a percentage requirement. It's not really a holding. I would say it's a dicta, but a percentage requirement is not a percentage recovery to unsecureds is not a requirement. In other words, there was an offer made like that. That was for some reason discouraged by the trustee, but that's not a requirement of a sale of an avoidance action, and that does not. And just because the trustee accepts a sum certain without any percentage recovery shared with unsecured creditors or the estate, that doesn't mean that the sale does not benefit all creditors. All creditors are benefited because money, the action is being sold and money is coming into the estate, and that's good enough to satisfy the legal principle that all creditors should benefit.